by a 7-judge bench in Bangalore water supply. I have also stated that it was not necessary to refer to a larger bench. The 5-judge bench could have reconciled or taken one of the opinions of the 2-judge bench or the 3-judge bench in Jagannath Maruti Kondare and Pratham Singh Narsingh Parmar, which both were on the social forestry issue. Of course, I have referred to the submissions in detail, and then I have taken into consideration even 10 reasons as to why it is not necessary to answer the reference. I will go to it in the summary. I have gone into the history from 1950 to 1991, planned economy to liberalization, privatization, and globalization. Then I have analyzed each of the opinions of the honorable judges on the bench of Bangalore water supply, Justice Krishnaiyer for himself and Justice Bhagwati and Desai, then the opinion of Chief Justice Beg, then the opinion of Chief Justice Chandrachud subsequently, and the opinion of Justice Jaswant Singh for himself and Justice Tuljapurkar. I have analyzed the opinions in the Bangalore water supply on the triple test, then the overruling of Safdarjung Hospital, solicitor's case, Gymkhana Club. Why did Bangalore water supply overrule both these cases? Then I have given my further analysis. Application of the ratio of Bangalore water supply in reference to a larger bench. Why an expansive definition of industry is necessary, and summary of conclusions. When I come to that, I must just, being a student of history, I would like to say, one cannot lose sight of the precarious condition that India was when it gained independence in August 1947 and at the dawn of Republic in January 1950. The provisions of the Constitution of hence sought to achieve a transformation in the socio-economic conditions of the people of India, given the situation as it emerged in the colonial period. The transition of the Indian economy towards privatization and liberalization is ultimately for the welfare of the people of India. Heavy capital investment in the public sector in the early decades after independence and its failure to yield good results in the subsequent decades, and the move towards disinvestment and privatization are all experiments in achieving the constitutional goals which are constant, but the path to achieve them may vary with the passage of time. It is in the above backdrop that the judgments of this court must be viewed. Liberalization, privatization, and globalization was embraced by the Indian economy with a view to inter alia, privatize all those state-sponsored or state-managed industries by handing over of certain industrial units or entities and the production of goods and services to private hands. This significant development in the Indian economy has resulted in not only private investment in Indian industry, but also growth of industrial production of goods as well as proliferation of the service sector in the Indian economy. Privatization inter alia implies that whatever activities were undertaken by the state as a state-owned or state-sponsored project or program is now being conducted by private entities or under a public-private partnership. Therefore, workmen or employees who were working for public sector units were transformed as workmen of employees of the private sector. It is in this context that the protection of workmen as envisaged under the ID Act assumes relevance and significance. If this singular factor is to be borne in mind, then the interpretation of the definition of industry in Section 2J has to be broad-based, as per the majority opinion of the judges of the 7-judge bench, and not narrowly tailored. I said that I have given 10 reasons. For that, I will just read out in brief that firstly, because the ID Act itself has been repealed with effect from 21/11/2025. So why should we give an interpretation to the earlier provision? A new enactment by way of the IR code has been enforced with effect from 21/11/2025, containing a new definition of industry in Section 2B thereof. The judgment of the 7-judge bench has held the field for nearly half a century, 48 years. In Bangalore water supply, there is a broad consensus of opinion expressed in the concurring judgments of the majority of 5 judges. The points of convergence and divergence discussed by Justices Jaswant Singh for himself and Justice Tuljapurkar do not in any way dilute the ratio of the judgments interpreting the definition of industry in Section 2J by the majority of 5 judges. Any pronouncement on the correctness or otherwise of the judgment of this court in Bangalore Water Supply now would definitely cast its shadow on the definition of industry under Section 2P. And for this reason also, the judgment in Bangalore Water Supply does not require reconsideration. The application of the ratio of the judgment in Bangalore Water Supply cannot result in reconsideration of the correctness of the judgment of the 7-judge bench. In fact, in the Jaibir Singh, they had a difficulty in application, but for that reason, they found fault in the judgment of the 7-judge bench. Therefore, I have said that reasoning is also not correct. When the judgment of the 7-judge bench of this court was rendered in the year 1978, there were innumerable activities which were embarked upon by the state itself. Then I have gone into the LPG issue again there. Hence, in the interest of employers, workmen, and industrial activity, as well as the Indian economy itself, the definition of industry in Section 2J as interpreted by Bangalore Water Supply must be followed in the pending cases. The Industrial Disputes Amendment Bill 1982 has remained unnotified and thereby incoherent to this date. Therefore, the judgment of Bangalore Water Supply should be taken to have received the acquiescence of even the Parliament and the Executive, and therefore no interference by this court is called for. Any reconsideration of the judgment in Bangalore Water Supply will cause the disputes pending under the erstwhile ID Act to be now remanded to the original fora for reconsideration on the issue as to whether it is industry or not. This will only lead to uncertainty and industrial peace would not be maintained. The state undertakes many functions which are not stricto sensu sovereign. Merely because a function is performed by the state ought not to mean that it disqualifies for being exempted from the word industry. Then I have also answered the questions. The first question I have said that the test laid down in paragraphs 140 to 144 of the opinion of Justice Krishnaiyer is the correct law. And I have said that the 1982 amendment and the IR code do not have any legal impact on the interpretation of the expression industry as contained in Section 2J of the Act. Question number 2, social welfare activities and schemes or other enterprises undertaken by the government departments or their instrumentalities can be construed to be industrial activities for the purpose of Section 2J of the Act, depending on the nature of the activities. Because the government is doing these activities per se, they cannot be excluded from the definition of industry. Hence, the test of who carries out the activity is not relevant. Rather, what is the nature of the activity and all other relevant factors of the activity have to be considered to determine whether the activity is an industrial activity or not. Question number 3, the determination of state activities which would be covered by the expression sovereign function. I have said again that would depend on the nature of the activity. The interpretation given to the aforesaid provision in Bangalore Water Supply, it excludes certain activities from the operation of the sovereign function exception test and consequently places them within the definition of industry. Therefore, the dominant nature of the activity rather than the dominant purpose of the activity is the relevant factor. Then I have raised one more issue. The issue that arose during the course of hearing before this bench was whether the interpretation of the word industry in Section 2P of the IR Code could be applied to consider the 7-judge bench decision. And my answer is, that is whether Section 2P of the IR Code can cast its shadow on Section 2J of the ID Act, so that the interpretation of Section 2J of the ID Act could be aligned with Section 2P of the IR Code and therefore tailored down. In my view, the interpretation of the word industry in Section 2J of the ID Act may have a bearing on the interpretation of Section 2P of the IR Code and not vice versa. I also wish to add a caveat that I have not said anything on the definition of industry under section 2P of the IR code. The reference is answered accordingly in the aforesaid terms. I thank all the peer advocates, instructing counsel who have assisted this court and this 9-judge bench in and enabling me to deliver my opinion. Thank you.
Thank you. I have commenced with indicating what is the lesson that we have to learn if a definition eludes us from 1947 onwards. I have indicated how the problem arose, not because of the methodology of interpretation, but because of the way in which the definition is formulated. So what should be the definition of a definition is also I have tried to indicate. I will skip all that and the conclusions only I'll read. The procedure by which the ratio in Bangalore water supply has been referred for reconsideration to a bench of 9 judges is valid. The endeavor of various decisions of the court after Bangalore water supply leading to reference by Jaybir Singh to bring about certainty about the way industry, what industry entails is justified. The reference can be answered on merits. I said can be answered. While an authoritative interpretation of the definition industry was compelling at the time of reference, such a determination has now become unnecessary with the repeal of the said provision with effect from 21/11/2025. With the advent of Industrial Relations Code 2020, with effect from 21/11/2025, the ratio in Bangalore water supply is now confined to cases arising under the repealed act. It is prudent to dispose of the pending cases on the basis of the ratio laid down in Bangalore water supply without attempting to create a third set of principles applicable only to the pending cases. Here I have completely agreed with the Chief Justice perspective of the hypothetical perspective of how in future, if we have to reinterpret the new code provisions, I've agreed with him on that. And I've also indicated that it is important to ensure that the future interpretation of the definition of industry under section 2P of the Industrial Relations Code 2020 is not burdened by the existing interpretations on the repeal of section 2J of the Industrial Disputes Act 1947. The Industrial Relations Code 2020 should be interpreted on its own text and on its own in its own context alone. Further, if the 9-judge bench modifies and restricts the ratio laid down in Bangalore water supply, it will have a serious effect of excluding certain entities from the fold of industries as defined under 2J of the repealed act. This will have the consequence of excluding long pending disputes from the regulatory regime of Industrial Disputes Act 1947, and the parties will be relegated to remedies before the civil court. It is therefore necessary to dispose of the disputes arising under the repealed act on the basis of the ratio laid down in the Bangalore water supply. This is my opinion. Thank you very much.
Thanks. I had shared my opinion with my sister and brother judges. Justice Ujjwal Bhuya concurred with me. So therefore, my opinion is on behalf of Justice Bhuya and myself. To set the context, I have given a prelude, and I'll read 2 paragraphs. A single definition in a pre-independent statute, since repealed after a little less than 8 decades of its existence, has troubled the Supreme Court without end. Prior to its repeal by the court, the ID Act had defined industry in section 2J, a definition which has perhaps been the most litigated word in Indian labor jurisprudence, as would unfold hereafter. Though the ID Act was enacted as a tool for securing industrial peace and harmony, what counts as an industry, private business, welfare work, or government service has been the focal point of discussion since long. Benches have differed time and again in deciding what should the law cover. Is it only business or also schools, hospitals, and government services? Even today, this court remains engaged with the same question it faced in 1952. What is an industry? And a split verdict is on the anvil. My opinion is spread into 12 sections. There is one section on institutional credibility. The last sentence there I would like to read. What is required is an authoritative determination that restores certainty, preserves finality, and enables the law to move forward. Institutional credibility demands no less. The lingering uncertainty surrounding Bangalore water supply must, therefore, be laid to rest. Thereafter, there is a section on whether the objection raised by Madam Jaisingh is valid or not. We have devoted 6 paragraphs, 24 to 30, to uphold Madam's objection. We said that Maruti and Parmar did not conflict. Parmar, in fact, on the basis of affidavit evidence, distinguished Maruti. So therefore, there was no question for the reference to be made in the first place to the 3-judge bench. Now, the 3-judge bench referred it to a 5-judge bench, 5-judge to 7. We have noticed 6 reasons given by the 5-judge bench in Jaibir in favor of a reference. So before dealing with each and every reason, we have tried to trace decisions of this court on the point as to when reference can be made. So we came across a 1965 7-judge bench decision in Keshav Mills Limited, authored by Chief Justice Gajendra Gadkar. Now that precedent was available before Jaibir 5 judges. Unfortunately, nobody placed it before Jaibir. And we have said whatever tests have been laid down by Chief Justice Gajendra Gadkar, 5-judge Jaibir fails each of the tests. There have been subsequent decisions, Shah Faisal and Balasaheb Patil. There also tests have been laid, although those decisions were following or after Jaibir would not have been considered, but the tests laid down do not seem to be satisfied in Jaibir. So we have given our reasons. Then, assuming that the reference is proper, we have dealt with the definition of industry. Here, I may point out, since this opinion was first of the block, and we have not changed a single word after reading the opinions of my sister and brother judges, we are not on the form test. Most of them have upheld the reference on the basis of the form test that Dawoodi Bohra has been correctly followed. 2 to 3, 3 to 5, 5 to 7, 7 to 9. We are on the substance test, whether the substance required this reference to be made or not. So we have thereafter dealt with 2J, why Bangalore Water Supply has correctly laid down the triple test. And thereafter we have reached our conclusion that to be clear, the reference made by Jaibir 5 to Jaibir 7 was not necessary and serves no practical, jurisprudential or doctrinal purpose. The reference seeks to disturb a quietus that has held the field for nearly half a century. Finality in law would be undermined without any corresponding public interest being served. We must remember, institutional credibility lies in respecting finality, not in perpetuating doubt. And absent compelling justification, none of which exists here, the chapter must be treated as closed. Paragraph 77, we have answered the 3 questions which were formulated by the 3-judge bench, presided over by the Honorable Chief Justice. Thereafter, we have said, we therefore order that all pending references arising out of industrial disputes under the ID Act ought to be taken to its logical conclusion in accordance with the law on interpretation of the word industry, subsisting prior to operationalization of the 2020 code. Since the bench was informed of a likely challenge to the 2020 code, nothing observed here shall have any effect on such challenge. To conclude, the reference is rejected and Bangalore Water Supply does not require any reconsideration. All pending matters may now be placed before an appropriate bench upon obtaining orders from the Chief Justice. And we have sincerely appreciated the efforts of the learned attorney, learned senior counsel and counsel appearing for the parties, and the learned MEC Curing for their wholehearted and erudite assistance in enlightening us to facilitate rendition of this opinion.
Thank you, Sir Juan. I'm in humble agreement with the opinions of the Honorable the Chief Justice and my revered brother Justice Narasimha that the reference was validly made. Why I say this is because the manner in which the ratio in Bangalore water supply has been referred to for reconsideration is in conformity with the law declared in Dawoodi Bohra, as affirmed in Aligarh Muslim University. The substance or otherwise is a matter of answering the reference on merits. As such, the reference requires to be answered on merits. On merits, however, I'm unable to agree with a reformulation of the triple test propounded in Bangalore vis-a-vis the definition of industry by the Honorable the Chief Justice. In this regard, I respectfully concur with the opinions of my reverend sister, Justice Nagaratna, and reverend brother, Justice Datta, that the triple test propounded in Bangalore correctly determines the scope and ambit of industry under the 1947 Act. Why I say this are my conclusions on merits. I hold that the triple test laid down by Iyer in paragraph 140 to 144 exhibits a rare felicity in judicial interpretation. Through such triple test, Bangalore, while remaining faithful to the text, extended the beneficial object of the law to all employer-employee disputes wherever the stakeholders are engaged in an organized systematic activity akin to trade and commerce to produce goods and services for the satisfaction of human needs, and did not restrict it merely to activities which are run on commercial lines. The criticism that it converts every organized human endeavor into an industry is misplaced. For the triple test, in fact, carves out just and proper exceptions in cases of casual and non-systematic activities like domestic service, individual professions, small and unorganized clubs, associations of persons. The other two questions with regard to public duties, welfare activities, charitable institutions I've held. In a constitutional democracy, the concept of sovereignty has undergone a jurisprudential contraction and is restricted to core inalienable duties for which the state is not answerable to courts of law, but to the people in a political democratic discourse. Viewed from this perspective, welfare activities of the state and schemes undertaken by government departments and their instrumentalities are not, by reason only of their public, charitable, or welfare character, placed beyond Section 2J. Mere vesting of a duty in the state by statute or by the Constitution, even a duty undertaken to fulfill the lofty mandate of Part 4, does not clothe it with sovereign immunity from industrial law. Articles 309 to 311 give little solace as they cover a narrow sliver of civil posts. In these circumstances, unless appropriate legislation engrafting equally efficacious remedies for access to justice is passed, to exempt statutory or welfare activities discharged by government departments or their instrumentalities from the beneficial scope of the ID Act on the specious plea of sovereign functions would leave a great multitude of workmen engaged in the organized undertakings of the state without the remedies which the said Act was enacted to secure. From the lens of industrial law, charitable undertakings, temples and educational institutions are all viewed not by the spiritual, religious, or benevolent object they pursue, but by the character of the employer-employee relationship through which they function. Where such activities are carried on through an organized and systemic relationship between employer and employee, they answer the triple test, and the absence of profit or the presence of a benevolent object does not take them outside the ambit of the beneficial legislation. Now, with the question of the 1982 amendment and the new law, industrial code, IR code, I have answered. The 1982 Amendment Act was never notified. It is settled law that courts cannot direct the government to notify an amendment, which is a part of the legislative process. In view of such disinclination, it would be wrong to rely on an inert law to redraft the Bangalore ratio. Similarly, the new definition of industry in the IR code has been given prospective operation, and in light of Section 6 of the General Clauses Act, preserving rights and liabilities acquired or incurred under the repeal law, the ratio in Bangalore water supply dealing with cases under the repealed ID Act ought not to be disturbed with reference to the new definition. Finally, what is the outcome? I am addendum with the Honorable the Chief Justice and my esteemed colleagues that the ratio in Bangalore would govern the pending cases or cases arising out of the repeal law, and the provisions of the new IR code would be independently interpreted. Why I say this is the ratio in Bangalore applies to a sunset legislation dealing with legacy matters and has been consistently followed for decades. Given the situation, in view of the settled principles of stare decisis, such interpretation, which yields to no manifest error, needs to be retained, keeping in mind the fact that the economic and technological changes since it was decided have weakened rather than strengthened the case for revisiting it. To overrule it now would unsettle rights and proceedings, doing more harm than good. It is apposite to note the ratio in Bangalore limited itself till a new definition was introduced. As a new law redefining industry has come into force, the ratio in Bangalore would remain restricted to the proceedings pending under the repeal law, and the provisions of the new law, that is IR code, shall be independently interpreted.
My Lord, the Chief Justice, I just want a little clarity that a potential challenge to the IR code has been left open on its own merits.
Just clarifying in the court short order we are passing, and there also we are clarifying.
Yes,
But
please.
all of us have,
Like, that's the understanding I got from all the five
all of us
different judgments.
have expressly said so.
Yes.
But in the sum up order also,
Greatly obliged, my Lord. On behalf of everyone present on this side, I would like to thank all 9 of you, my Lord, not only for the patient hearing, but the labor.
They're
wait,
they're giving a summation.
Dictating your.
just short order only, the instant appeals have finally been adjudicated by a bench comprising 9 judges after examining the ratio and accompanying principles laid down in Bangalore water supply and Sewage Board versus Air Reservoir. Sir, appeals made with respect to the ratio.
Reference.
He said appeals have been adjudicated.
Appeals will have to go back to the respective. Yes.
Yes.
Reference has been finally adjudicated by a bench comprising 9 judges after examining the ratio and accompanying principles laid down in Bangalore water supply versus Air Reservoir. Justice Surikant, Chief Justice of India, pronounced the judgment on behalf of himself, Justice Sri Sundar Sharma, Justice Alok Arade, and Justice Vipul M. Panchali, along with a substantially concurring opinion penned by Justice P.S. Narasimha. Next paragraph, Justice P.V. Nagratna has expressed an independent opinion holding that the reference to a 9-judge bench is not maintainable. Similarly, Justice Dipankar Datta wrote for himself, and Justice Ujjwal Bhuiya has also declined to entertain the reference on grounds of maintainability. Whereas Justice Yomala Bagchi has rendered an independent opinion holding the reference to be valid while affirming the ratio and principles laid down in Bangalore water supply. Correct? Water supply. The majority opinion has thus held that the reference was validly made and that no objection can legitimately be sustained as to its maintainability. Next paragraph. However, it has been expressed with abundant caution that the majority opinion on the reformulation of default test will only operate prospectively and is not intended to displace the governing legal position in respect of pending proceedings. Consequently, all matters presently pending before courts, tribunals, labor authorities, or other fora under the Industrial Dispute Act 1947 shall be adjudicated in accordance with the triple test laid down in Bangalore Water Supply Supra. Next para. The majority opinion has refrained from entering into an examination of the definition of industry as it exists under the Industrial Relation Code 2020 or the Industrial Dispute Amendment Act 1982. Accordingly, and pursuant to the conclusions set out in our judgments, the principles laid down in Bangalore Water Supply shall not be regarded as set out in the majority opinion. The principles laid down in the Bangalore Water Supply Supra shall not be regarded as sheet anchor for the interpretation of the IR code, the Industrial Relation Code 2020, or any of its provisions. Should such a question arise in the future, and such questions shall be interpreted at its own text and context. The requisitions are accordingly disposed of. All pending applications. References accordingly disposed of.
Once again, my lord, my gratitude.
The appeal appeals are.
I'm in a hurry to give you my gratitude, but
We have also.
my lord, just the gratitude, not only for the time given to us to make our submissions, but I, for one, my lord, will read each of the 5 judgments for the jurisprudence that I can get from it. I'm very grateful.
Well, just two things. I think Justice Bagchi, from what he dictated, may be at odds with the order that your lordship said. He's in agreement with the reformulation. I'm not sure.
He is in agreement with only reference minting.
Reference. Yeah, that's fine.
His
Well,
majority has not affirmed
Correct.
Bangalore,
Yeah.
left it open-ended,
Right.
but will apply to all present cases.
Right.
On the interpretation of the court, it will be determined on its own basis.
But it's also our gratitude to all your lordship's clerks who have assisted you all through this. I think it must have been a massive exercise.
Yes.
Gratitude.
And all of you rendered an outstanding.
All of you are
Very
Grateful to the bench, very grateful to the bench.
Thank you very much.
very
Like-
varied and very interesting arguments by all of you. Thank you very much.
Thank you.
Grateful.
Grateful.
Ready to make your business official? Aero AI Builder can help sort all of that out for you. No coding required, no design skills, just a simple conversation. Head to aero.ai and start by describing your business. Click Generate. Then it serves up a homepage, a logo, brand colors, brand fonts, the whole shebang. Now you've got a professional website. Not bad for something that started with just a simple conversation.
इंडिया वर्सेस पीसफुल स्लीप। पूरी रात कोई पोजीशन बदले, कोई बैक पेन को कैच करे। इसीलिए अपग्रेड टू द स्लीप कंपनी, इंडियाज फर्स्ट एंड ओनली स्मार्ट ग्रिड मैट्रेस। दे सॉफ्ट कंफर्ट, फर्म बैक सपोर्ट and 8 hours of peaceful sleep every night. The Sleep Company. Visit your nearest store now.
केरला के वायनाड में भीषण लैंडस्लाइड, जबरदस्त जान और माल का नुकसान। असम और हिमाचल जैसे राज्य बाढ़ के प्रकोप में उस साल डूब रहे थे। लोग रिलीफ कैंप में दाने दाने तक को